And now getting into the reason why we're all here, I'd like to introduce Louis Leo. He is a partner at DLA Piper. In addition to the co-chair of U.S. Emerging Growth and Venture Capital, he's also a co-managing partner of DLA Piper's Silicon Valley office. And with that, I'm going to go ahead and pass it off to Louis, who's going to explain more about his experience in due diligence, and then we'll get started with the webinar. So Louis, I leave it in your hands.
Patrick, good morning, and thank you so much for bringing us into this program. On behalf of the partners at DLA Piper, we're very excited to be working with 500 and your portfolio of your ecosystem of members, and we look forward to helping contribute and hopefully make it better. Can everyone hear me okay? Patrick, can you hear me okay?
Yep, I can hear you great. Seems like everyone can hear you.
Wonderful. I will skip the advertisements, but I'm just a local boy from the San Francisco Bay Area, born and raised, started my career on the East Coast and came back 15 years ago. And what I enjoy doing is helping birth new ideas and turn them into new companies, and then help them go get from friends and family money to angel money to hopefully venture money and hopefully great exits. And I brought my practice and my team to DLA Piper really because we have a vision that technology has no borders. And we have built a platform of 4,400 lawyers in 90 cities and 40 countries so that we can be in all the places where technology companies need advice. And really that's the way to think about us and how we can add value to your business. In my law practice, I represent a lot of different investors. And in fact, we're the #1 law firm advisor to investors according to PitchBook. And we spend a lot of time doing it in a formulaic way and a systematic way to make sure that we're picking up the most important things that matter to investors. So today, I've put together an agenda of items that we could talk for hours about. We won't. And really, these are kind of the main headings of what we look at, at seed stage for investors to make sure that the investment is sound and that it's on a good footing for a subsequent venture capital round or some other great outcome. And so before you see an agenda of what those topics are. I'm hoping that this will be an interactive discussion because hearing me talk will be boring. Patrick, I don't see the question function at the bottom right now, but please, if you see questions, voice them and interrupt me so that we make this a little more interactive and fun.
Absolutely.
I think that we're all here because we have a passion for technology companies and what it can do to change our lives and to make our lives better. And often the first question I get from a seed stage investor is, "Hey, Louis, when should I call you, or when should I get legal counsel?" And I think the answer there is after you've met a number of times with a founder or a team, you've become convinced that the technology they have is a solution that the world needs. That they have a team that you believe in, at least for a specific stage, and that you've decided that you're going to make an investment of some amount of money. And oftentimes, people will ask me to write a term sheet. People will ask me to look at the term sheet they've already put together, or to help them put together a template of a term sheet that they can use all the time with some variations for that they should think about on each investment. And people also ask me, who's the right lawyer for me? And I have a blog post on our DLA Piper Accelerate blog that answers that question. And I think it's a really personal question about who do you connect with, who answers your phone calls, who has experience representing investors and representing companies and in the space that the company is in. All of those, I think, are really relevant components. And of course, in the places where the company is going to be doing business. So fast forward, you've met a founder team, you're convinced that they have something, you believe in the team, and you want to make an investment, and you've given them a term sheet, they've signed it, and then and only then will we start what we call legal due diligence. And that process typically starts with the lawyer, let's say it's me, just for purposes of this discussion, but it could be you, issue to the team a legal due diligence request list. It's usually 3 or 4 pages. It's designed for the company to be able to respond to it and track changes, or check boxes in columns that, yes, I've given it to you, yes, I've put it in a Dropbox or in a data room, or no, it's not applicable, or it doesn't exist. We give that to the company you're going to invest in. I'm going to call that the target from now on, just to make it easier for nomenclature. So you give it to the target, and you say to the target, take a week, go through this with your team, populate the response to this chart and any documents that are responsive to it. And sometimes topics are best answered by a phone call, and just indicate that. Post that in your Dropbox or in your box or your virtual data room, together with all the documents that are responsive. And then and only then is the time to go start looking at it and the answers. And I say that because, if you start looking at the data room on an iterative process, on an iterative basis, on a day-by-day basis before it's done, you end up spending a lot of cycles. Well, why did you answer this question, not that question? Is it complete? Is it not? You ask follow-up questions that the company just hasn't had time to respond to, and it ends up taking longer. So I usually tell people, take this list, take your time, annotate it, fill it out, put together everything that's responsive, and then and only then give it back to me. And on this agenda slide are kind of the main topic areas, and at that point I will send in a team of 2 or 3 lawyers, maybe only 1 depending on the complexity of in the age of the business, to go through it as hopefully in a day or 2 because it's complete, and analyze it. And we start off by looking at the formation of the company. And we at DLA Piper, whoever your counsel is, or a registered filing agent, can first pull the certificate of incorporation and any amendments. This is a document that declares to the government that a corporation has been formed. Most companies that will seek venture capital are formed in the state of Delaware as a C corporation. It's a very small minority that are formed in other states. And there has been a trend in recent years of forming a California LLC at formation and then flipping that into a Delaware C Corp upon a significant funding event. It isn't usually recommended, but it often happens for personal tax reasons of the founders. But there should be a certificate of incorporation, and we pull that together with any amendments. And we look at it to understand what are the rights and obligations of the holders of stock as they exist at the time. Who has a preference if there is a liquidation event, who gets paid, in what order, and how much. Whether there's a dividend, how the company is controlled, that there's a board of directors, how many directors. It won't say who they are necessarily, or even how many. That might be in another document, which would be the bylaws, which is not a document that's publicly filed, but that will be made available to you and is adopted at formation. The certificate of incorporation is the relationship that governs what happens as between holders of securities, the government, and the company. The bylaws is a document that really governs how a company is managed on an internal basis. And it typically says that a company is supervised by a board of directors who appoint a management team, and then it's operated by a management team, and it has all sorts of other regulations about how decisions are made, when board or stockholder meetings happen, when people can be replaced, et cetera, et cetera. So that's a very important document to receive and understand. There was a trend starting about 10 years ago where companies included some pretty detailed restrictions on the transfer of securities that are already issued within the bylaws, and how that can happen. And that's pretty important to seed stage investors to know. How do they get liquid? And if they have to first give, for example, the opportunity to the company or another investor, the opportunity to buy their shares or match another offer, and whether you have to disclose the terms of a third-party offer to the company before you make a transfer. Those are pretty important things to understand before you make an investment. At formation, there will also be some sort of a corporate action that will adopt the charter and the bylaws and then appoint a board. We need to see that because that's the first action that starts the chain of dominoes to understand, what legal rights and obligations does the company and do the holders have. It starts there. So that's something we'll want to see. We'll also ask for a certificate of good standing from the state of incorporation and any other state that it's qualified to do business in. And this we do to know that the company has paid its franchise tax, for example, that it's complied with its filing requirements and is authorized to do business where it's doing business. So that's a pretty important document. In some states, like the state of California, we also look for a certificate from the Franchise Tax Board that there are no delinquent taxes and that the company's in good standing there. So Delaware Secretary of State is who issues a certificate of good standing for Delaware C Corporation, and then the state of California would issue a Franchise Tax Board certificate, for example, for a company in San Francisco. We'll also want to know where the company, or whether it has any subsidiaries or affiliates where it's qualified to do business. And this is really informative. Hopefully there are no major bugs in there. But many corporations at formation stage are done using document services, LegalZoom, other entities that do a very good job helping companies get organized and legal, but not necessarily ready for venture capital. So sometimes we amend and restate those documents so that they have the terms that a seed stage or a venture capital investor would expect to see and make them comfortable that an investment is okay to proceed with. So that's what you need to know about formation. Again, what are we looking for? We're looking for non-standard, off-market, toxic provisions that we would want to remove, amend or restate, or we're looking for gaps, places where the low-cost incorporation service hasn't thought through, for example, how the board gets appointed. So we amend those provisions through a board and then a stockholder's consent in connection with the financing right before that gets adopted right before we issue a check. We then look at the other steps that were taken in connection with the organization. We look at all the board and stockholder minutes and resolutions. We look at whether any securities were issued yet. And we look for any kind of legal entity organizational chart, again, to understand that there's a record that exists of all of the actions that have occurred. And if not, that we adopt a ratification resolution that confirms the legality of everything that's happened, and we make sure that what needed to happen happens. Oftentimes there are minutes that are missing, documents that weren't thoroughly signed, and again, these can all be cleaned up through a ratification of a missing or a defective corporate action. The next big item we look at is the cap table and the capital stock, because obviously we really need to know how who owns the company, who controls it, who has been in and out of the securities. We want to make sure that particularly for a very early stage company, that let's say we're going to invest $1 million and we're going to get 20% of the company, just for ease of math. That means $4 million is going to be owned by the founder team, and if this is an early stage company and they're to walk away, that's a big problem for our ability to retain a new team, for everybody to feel like it's fair. And so we often ask that founders at formation agree to be subject to vesting for 4 years. And the first year of vesting is usually a 1-year cliff. So nothing vests if a founder leaves during the first year, the most critical year of a company's growth, that they give up their stock in total, so that we can give that to another founder. After a year, we think that the founder has earned a quarter of her or his equity stake, and that the rest of it should vest on a monthly basis. So we're looking to understand how much of the founder's stock has vested at the time we invest, and whether we're comfortable with that level, whether we think that some additional revesting should be required, or that we're comfortable that no additional vesting is needed. We also want to make sure that there's a record of everyone that's received stock. And if we've heard in our prior meetings that Jane, the CTO, says she owns a quarter of the company, that it's actually on the cap table, because if it's not, there are going to be some significant tax impacts to getting that stock to Jane now, both to the company and to Jane. And we want to understand what that is so that we're setting up the company for success, and we're making sure Jane feels very vested in the success of the company. We're also looking, when we look at the capital stock, for any agreements relating to voting, issuance, transfer, prior sales. Who owns stock, who owns options? Does anyone have a warrant? Have we given a warrant to a landlord, or to a bank, or to our Aunt Jane? We're looking to see that tax records were filed. So you'll often hear about 83B, and there are blog posts on all of these topics on our website, dlapiperaccelerate.com, which go into greater detail. But Section 83B is a section of the tax code which says that if your stock is subject to vesting, and if you declare the value of the stock at the time you receive it, the tax authorities will recognize that your basis was what you said it was, and that any gain you make on its subsequent sale will be the difference between the amount of the sale and the amount you declare on the 83B filing. So it's very important to know that you're going to get capital gains treatment on the full amount, and not ordinary income treatment, which can be pretty punitive, particularly on when it's looked at from both a federal and a state and even a city basis. In New York, you have state and city income taxes that you've got to make sure that you're paying, and so an 83B election is very important to know. And if it wasn't filed, what do we do about it? And that's a complex analysis. It's beyond the scope of this call. We also want to know, who are the employees and consultants? Are they on the stock option register? Do we think that the team that we need is incented and locked in to go make this rocket ship fly? And inevitably that equity is correctly issued and ownership is completely documented. I'm going to avoid using any names of companies in this call to avoid conflicts and offending anyone, but there was a famous case a couple of years ago where an autonomous vehicle company had been formed and then sold to a major automotive manufacturer for a number that started with a B, and there was subsequently a person who claimed that he had been a co-founder and that he owned a significant stake and that he had not been paid, and there was litigation, and I'm sure that while the settlement of that litigation may not be public, that was not a cheap thing to make go away, and so we look to make sure that the equity is completely documented. Lots of issues, we've talked about that can happen here, whether it's vesting of founder stock, restrictions on the transfer of founder stock. We don't want the founder to be able to transfer it to anyone. We want the founder, if the founder leaves, to offer her stock back to the company at the then fair market value, so that it doesn't get into the hands of a competitor or somebody who's just not participating in the success of the company. And there can be other red flags that we find, from non-dilutable equity shares that say, and I am always going to have 10% of the company, or that when the stock was issued, there wasn't enough authorized stock in the certificate of incorporation at the time of sale, that the options weren't approved, or that there are agreements that require approval and which approval wasn't obtained at the time. And so we typically find these issues and we problem solve how to resolve them. So I'm going to switch away from these corporate law topics now and switch into some topics related to the intellectual property of a business, which oftentimes is what we're investing in together with the people. So in our due diligence request list, we asked to see a list of patents, copyrights, trademarks, Oftentimes there aren't any yet, so it's a discussion about what is patentable, what is trademarkable. Um, we look to make sure that all of the intellectual property related to the business has been transferred to the company, and that it isn't the separate property of the founders. And so there are two documents that we often get at formation from founders. One is a contribution agreement of intellectual property in exchange for shares, and that means that everything that was created, the idea, and essentially that was created before the company was formed, then belongs to the company. Then from formation, we want the founder or entrepreneur or employee or consultant to sign a proprietary invention, pardon me, a proprietary information and investment assignment agreement. Gosh, let me do that one more time. Proprietary information and invention assignment agreement. So we want to make sure that anything related to the company belongs to the company, whether it's just information or intellectual property. And we want to make sure that everybody that's participated in the creation of the company's intellectual property or that has access to its confidential information has signed agreements to make sure that it will stay confidential and it will be the property of the company. This is very important that we identify this as if a founder is disaffected and leaves, what is to stop him or her from creating another company that is attempting to do the same thing? That's the issue, is to make sure that the company that you're investing in actually owns the information and the inventions. Oftentimes, businesses are going to rely on licenses from other people, so we call that an in-license, or it's going to make money by out-licensing their technology to a third party, and we want to understand what those documents are and how they exist, whether we have to pay money, whether we have the right to receive money, how those can be terminated, bought, or sold. And really, as an investor, you want to make sure that the business that you're investing in is going to have value and rights to that intellectual property in a way that you're comfortable that can be monetized in the future. Finally, we're always on the lookout for any allegations that or any information that would lead us to believe that the company would be infringing somebody else's intellectual property. And so if your founder team is exiting a major technology company, we want to make sure that the idea of their new company doesn't already belong to the company that they're exiting. So we're going to want to see the proprietary information and invention assignment agreement that they signed with their prior employer. And we're going to want the founder to explain to us why the intellectual property that she's creating in the new company doesn't belong to the old company. That's something that's very important at the formation stage. And again, all of this, we want to make sure the company owns its IP and it can develop it and do everything that it needs to do. The company is going to have IP before it was created and after it was created, and we want all of it. And so if, you know, just so many things that we're looking for, we've got some of these red flags listed on the bottom of the page here on page 12. Really, the big ones we're looking for are failure of employees or contractors to sign PIIAs, failure to get NDAs before showing technologies, or registering intellectual property under the founder's name rather than the company's name and not transferring that subsequently to the company. So those are some of the things we're looking for. The messy business of startups is most often with the people. And when you're investing in a startup, you're really investing in the idea, and the idea requires novel intellectual property, and it requires people to execute on that idea. So we want to know who are the founder teams. Was there a prior founder that exited? Who are the current and the former employees and consultants, and have they signed those documents that I referenced before? Were they paid money? Did we pay taxes on the money that we owed? If they were consultants, we didn't have to pay taxes. We have to issue a 1099 to that consultant. If it was an employee, we had to pay payroll tax to the state of residence of that person or where they're working, and the federal government. If they terminated, we want to see a separation agreement. We want to know that that person does not maintain a claim against the company. And that's really important, that our founder teams know that if they ever separate from anyone, they always want a separation agreement. We want to see the offer letters to know what was promised to these people, and whether we lived up to whether the company lived up to its promises and isn't walking around with a big liability. Most companies that are well advised at formation will have adopted a form of stock option plan, and may have granted stock options by the time you as seed stage investors see them, and we want to know that was done properly pursuant to a stockholder and a board approved plan, that the stock options were granted at fair market value, and that they don't offend any other tax rules that would trigger a patent or a latent liability of the company. We're looking for loans and guarantees for the founder team. We need to know what those are and that they're properly accounted for, and any other agreements with these people. Are we renting office space at above market rates from the founder team? Are they the landlords? Did they register the IP in their own names, and we're paying some sort of a license fee to the founders for the IP, and that they could sever that agreement at any time? Is the founder team employing all of their relatives and appropriating funds from the company? So there are a lot of things that we're looking for relating to employees, and this has really got to be an area of deep focus for you as seed stage investors. Is there are going to be problems, and we have to figure out what's the game plan to go fix it. Some of the problems that we see are red flags, failure to put things in writing, whether the employee is under some sort of a non-compete, whether with us or with a third party, and that non-compete is legal. Making sure that employees know how to treat confidential information of their current employer and their prior employer. We don't want to get a knock on the door from a prior employer telling us that everything we've done belongs to them. I guess one of the most frequent problems, which is intractable and ubiquitous with startups, is they have not paid their employees typically and they've promised everyone that they'll pay them when they get funded. And here, we definitely have a liability, and how are we going to go solve it? And that's beyond the scope of this call in this webinar, but that's a very common problem that we need to go and resolve. Next big topic that I want you to think really big about is, what is the business that we're operating in, and what part of the government oversees this area of commerce? And I think a good example is ride sharing. When ride sharing first became an app, this was an area that was just regulated by city governments and authorization of licenses of people to operate as a taxi, or in the city of New York, it was a medallion. There are rules around how that can happen. And so you really want to understand, what is the regulatory situation of the company, and who's the regulatory body, and what status of compliance are we in, or are we going to be out of if we proceed with the company's business plan? We like to think that we're technologists and disruptors. And so if we're looking at a business, we're probably using technology to disrupt some existing way of doing things. And it's maybe just to be expected that to be able to execute our business plan, there'll have to be a change in regulation or law, or an evolution or a position. And we really want to know what that is, and whether it's reasonable, whether it's going to happen in any kind of near-term horizon that works for the company's development. We're going to look to see whether the company is in any kind of litigation or dispute with a prior employer, with the government, with tax authorities, with a licensor or a licensee, with an employee or a consultant. And really, this is just a big area that that we look at, and we ask a lot of questions, and we try and understand the extent of what our exposure is going to be, and what's the upside, what's the downside. So again, here on slide 16, some red flags. I go to tax now, and for a company that's newly formed, it's never recognized revenue. You're maybe not so worried about the federal, state, and local tax return, because whatever it would be, it would show that there's nothing owing if it's a pre-revenue company, hopefully. But you'd be surprised. A lot of founders will operate personal consulting businesses out of the company that they founded for technology disruption, and the consulting service that they make a living from while they're trying to develop the business has nothing to do with the technology, and receiving money incurred or triggered an obligation to pay tax. And was that done? Was stock issued at fair market value, and did we have a third-party valuation expert establish what the value was? That is a big business for financial expert firms to do, as it gives a safe harbor under the tax code that the tax authorities will prima facie assume that such valuation was correct and not challenge something unless they have reason to believe it was fraudulently or wrongfully procured. So we want to look at whether or not stock was issued at fair market value at the time that it was issued. Same with options. If the company was filing tax returns, whether the IRS issued any audit adjustments, or whether an audit firm was engaged, and whether they asked for adjustments, or whether they've filed their returns, whether they filed extensions, whether they received correspondence, all of these things. And particularly for these companies that were previously LLCs and converted, remember that if it was a conversion, you're the successor, and you really need to know what came before. And so this is a kind of a high-level area that we look at, and in the later stages of growth, it becomes more important in terms of amount of sales tax or income tax that could have been filed. But at formation stage or seed stage, we're looking to make sure that payroll tax was paid if it was owed, and that we have made our 83B filings, and that we are not in a negative position in respect of 409A of the tax code. I forgot a big one. I see this issue probably more than any other in the ecosystem of emerging growth companies, where people begin working for startups as independent contractors. They spend the majority of their time working for the startup. They operate, they perform an essential function. They represent themselves as the representative to the outside world for the startup, and they really aren't independent contractors. They're employees, and they were not classifying themselves truthfully, and the company has a patent liability to the government for payroll tax. And this can happen when the independent contractor separates herself or himself from the company and says, hey, you didn't pay my payroll taxes, I want unemployment benefits, and you were 1099 me as an independent contractor. It wasn't true. You should have given me benefits. You didn't. All sorts of issues. And the longer these issues don't get solved, the bigger the liabilities that accumulate and the penalties. And so we like to identify what these are right away, and resolve them right away. And oftentimes that's going to the government and telling them, hey, we've discovered that we weren't in compliance. We'd like to get into compliance. This is what we offer to resolve and reclassify the employee and pay any back taxes or penalties owed. And the sooner that we do that, the better we are. Next, I want to go to the topic of management teams. And really, this is who we're investing in. These are going to be the stewards of our money. They're going to be the visionaries of of the disruption, the architects of the takeover. These people are so important to the success of the enterprise. And if you've hired us and you've issued a term sheet, you're probably convinced at this point. Frequent issues. You find out that the founder is actually still a full-time employee at XYZ company. I'm going to call them Hulu from the TV show Silicon Valley, just for good humor. And they need to be devoting their full-time efforts to spending the money you're giving them to take the company to where it should go, and that they're not operating the company as a part-time hobby. I really recommend to my investor clients to always conduct a background check and a reference check on anybody who's a director or a C-level officer. And there are commercial databases that are very inexpensive that can pull what's knowable from public databases. It does not have to break the bank or be super expensive. Your lawyers may be able to do part of this legwork, although they're not usually the most efficient party to do this. I use a firm called VCheck Global to do this for me, and I find that they're very cost effective, and they find what's findable from searches, whether it's state records or just what's on the internet, or what you might find by one of the other commercial search firms. You'd be amazed at what you find. And if somebody owes the government $1 million in back taxes, that's a big red flag. If somebody has a prior record of conviction, you may want to understand whether that relates to their moral turpitude and their trustworthiness, and whether they've been forthright with you, whether a customer would be comfortable with them. You want to understand the org chart and who's reporting to who, and whether that makes sense, and whether talent is positioned where it needs to be. I often find seed stage investors telling me that they like the team, but they don't think the team is going to be the permanent team, and maybe they think they want to bring in a professional CEO, or they want to bring in a CTO, or some other member of the team that they think is critical to making it successful. This is the time to understand what it is. Once you've written that check and it's been cashed, it's hard to go architect changes without breaking glass. Really, is this team the team that's able to execute on the business plan, at least until the next round of financing? That's what we need to know. Finally, before we turn this over to questions, I wanted to throw out, some other, issues that we often look at. If a company is already recognizing revenue, they've got customers, you might want to look at what those forms of agreements are, how quickly they can be terminated, whether the company has put its intellectual property into a source code escrow, and how the customer could break that escrow and take the company's intellectual property. That's important to know. What do you know about the company's finances? Have you looked at their bank statements and records? What about their technical setup? Are you comfortable with it? Have they borrowed money from a bank or from a friend? What convertible notes or safes or KISSes or other instruments have been issued? What are their go-forward financing plans, and is the amount of the aggregate seed money that you're going to put in going to be enough to get it to the next stage? What other agreements have they signed that don't make sense? Can we terminate them? Are they free to compete? These are all critical, go no go issues that we look for in legal due diligence. People often ask me, what does all of this cost? And really, I think the answer there depends on the speed of the company's response to our legal due diligence request list, the thoroughness of the response, the age of the company, how long it's been in operation, the number of founders and employees, the number of stockholders, and the really the number of customers and what we really need to do to get comfortable and help you get comfortable that this is a good investment for you. Happy to answer questions about that offline, as the circumstances are always so specific that there are no kind of rules about that, and really the best process always achieves the best results. So here on this slide, I've listed kind of a key takeaways for all of you to take with you, as you proceed in building your funds and your programs and investing in companies. This is what I wanted you to know and learn, and from here, I'd love to, Patrick, to open it up to questions if there are any.
We are getting quite a few questions, so it seems like a lot of folks are very interested. And just to dive right in, this question is, how concerned should a U.S. investor be if a Chinese investor is already on the portfolio company's cap table and a CFIUS was not addressed?
That is a great question. I have spoken a lot about my belief that America and Silicon Valley needs China. We need Chinese capital. We need access to Chinese markets. It's a big part of the world. And for technology companies to be big and global, they need access there. And I believe Chinese companies need our technology, and they need our markets to be successful. And so I really hope that we can continue to find ways to do that. CFIUS refers to something called CFIUS, or the Committee on Foreign Investment in the United States. It's legislation and an oversight structure that has existed for 20 years or more, many years, and in light of recent developments in Sino-U.S. relations, the U.S. government passed a law called the FIRMA last August, which requires that that non-U.S. investors that are taking investment stakes with control or rights to information in any of 27 critical industries must first make a mandatory filing with the government and wait 45 days before they close their investment in order to legally comply with the FIRMA, which is this new piece of legislation. In addition to that, during the review or after the review, the government can also require or request that the investing party and the company make a longer form voluntary filing so that the government can review the investment in greater detail. And usually, if they're asking for that, they're going to ask the company and the investor to enter into a letter of agreement, or an LOA, with the committee, the government, giving comfort that the technology being developed is not going to leave the United States or end up in the hands of a third-party government. And there's a lot of scrutiny on Chinese investors and those investors' affiliations with the Chinese government, the Chinese military, and inevitably where this technology is going. And so the risk is that if a company has taken money from a non-U.S. party when the FIRMA had taken effect and did not make a filing, that it's not in compliance with law, and that investment could be ordered to be undone by the government. Or at the time of a liquidity event later, a buyer says, who would otherwise want to buy this company, says, "Oh my gosh, there's a risk that the U.S. government unwinds all of these transactions. I don't want to participate. There's a red flag. I'm not going to participate." So that's a big risk to value. So I think that this is a common problem right now, and I think people are working through it proactively. Of course, there are going to be a lot of foot faults and mistakes, as people get familiar with this new regulation, and you should bring that to the attention of counsel and seek a way to go through it. And there is no answer to that, but it's certainly an issue to look for, and it's an issue that hopefully can be solved in some way with the intervention of good counsel.
Great. And then the next question is, how do you remediate diligence issues such as export control violations? And an example of this is doing business with Cuban companies.
That is another great question. You know, at the same time as the U.S. government is adopting new rules to understand which non-U.S. entities are investing into what technologies, and the government's identified 27 technologies that are of critical importance to national security. They've also looked at increasing the enforcement of existing controls on the export of technologies to other countries. And this is a really big issue today, and not only with startups, but with large companies, is making sure that they're complying with those regulations. The consequences here can be criminal, in addition to civil. They are real, they are important. How they get cleaned up if they're identified is a very specific facts and circumstances analysis. But certainly mistakes happen all the time in the flow of commerce, that a transaction does not comply with U.S. export controls, and it's identified and it's raised and it's dealt with, whether that's making a declaration to the U.S. government that a mistake was made, or determining that putting new controls in place to ensure that never happens again, and the extent of the remediation. So very facts and circumstances analysis, but it's a great question.
Thanks for that. And here's an interesting question. So some promising startups are incorporated in jurisdictions which do not have mature legal systems, and that they're unable to mitigate or address interests of investors. In such cases, would you recommend that they reincorporate in a more mature jurisdiction, like Delaware or C Corp, or is the potential risk significant enough for you to walk away?
So, being a DLA Piper and practicing where I do and what I do, I see this question a lot, and I've dealt with it many different ways, and I'm a lot more sanguine than I used to be. The textbook answer, if you're coming to Silicon Valley, is that an investor only wants to invest in a company that's incorporated in Delaware, where that company ultimately owns all the intellectual property of the business, and where that company has privity of contract with all of the people that created the technology, and that's where you're putting your money. And so I think the textbook advice 10 years ago, or even 5 years ago, was form a Delaware C corporation that's a subsidiary, and then either do an exchange of shares with the shareholders of the non-US entity that is from this non-mature jurisdiction, or do a downstream merger, or do an asset sale, or do a license, as if the non-US entity was a university, and you're going to upstream some revenue stream to the old shareholders through a license. So those are the typical ways we do it, and I've done all of those methods, and I've had some successes and some failures. And I guess one piece of advice is to take your time. I find that a lot of investors come here with the intention of raising money from U.S. investors, and ultimately they discover that their home country investors are the ones that understand their business and their people and their opportunity the best. And just having a branch here, an office, helps them raise money in their home country, or helps them, otherwise. And so I would say not to go do this flip until you have real interest from a seed stage or a venture capital investor. Now, my advice to the seed stage investors is, where is this company going to be getting its next round of venture capital? And if the goal here is to get U.S. venture capital, absolutely, we need to flip this to a Delaware C corporation. But if you're not sure, it's a question. Should you wait to make your investment until you are sure? Should you invest in the home company, the home country jurisdiction? Is that in Hong Kong? is it in Caymans? Is it in the UK? Those are all places with mature legal systems that might have very good benefits. Is it in Estonia or Gibraltar? Does it look like something that if it was published in the Panama Papers that you invested there, that you'd be embarrassed? These are all considerations to think through carefully with good counsel and the other people around the table that are putting money in.
Excellent. That's always a question that I hear all the time as well. So this is another question. So we'll pay you once we get funded. It seems like a reasonable thing for a CEO to tell his or her employees. Is the concern re-promise of back pay, or that the pay promise is too high, or something else? So they're curious for a little more details on this point.
So first off, the law is the law, and we have minimum wage laws in federally and in every state that I'm aware of. And if somebody makes a claim for wages, the directors of this company could be personally liable. And so it's a big thing to get your head around. But every startup has a point, that they're doing business, or they're getting together and they're working with people and they don't have money yet. So there's a chicken and the egg problem that happens in almost every business. And so this issue arises in almost every business. The problem is the longer the time goes by between when the CEO makes this promise and when the company gets funded, if that's a year, and there have been a lot of people working on the product, and you're raising $1 million seed round, you're not going to want all $1 million of that to go out and back pay. And investors are not going to be interested in having their money go to the past. They want their money to go to the future. And so it's a very facts and circumstances analysis of how to do that. Is it a reasonable thing for a CEO to ask? It's not simple. It's how it's going to happen, inevitably. So there's my answer, Patrick.
Sounds good. Great. And then I think I have time for maybe one more question. And this is, so what type of due diligence do you recommend if we are not leading the round? So a full, complete one, fully vetted, or just a basic one and then rely on the lead investor?
Yeah, I think it's real common to rely on the lead investor, but you should know who is the lead investor and what did they do. And are they actually doing legal due diligence? I would not assume. People often write checks for relationship reasons because they trust a person from a prior interaction with them. Nothing replaces a background check. I can't tell you that enough, that a background check in whatever, the more background check that you can do, the better. Even one on one of these, Google searches that you find. I think that it's going to depend on the facts and circumstances. And oftentimes the follow-on or the non-lead investor will have a conversation with the lead investor's counsel, and we'll have the opportunity for an hour to say, what diligence did you do? What did you find? It's usually not efficient to have a written report for a seed stage legal due diligence, and so you won't get a written report. You'll be able to look at the disclosure schedules to the stock purchase agreement and hopefully have at least a 15-minute discussion with the team that conducted the due diligence, which is not just legal, but financial, business, technical, etc. Thanks, Patrick.
Sure. Yeah. So do due diligence on those who are doing due diligence. That is a great response. Yeah, so that is unfortunately all the time for the Q&A. We do have several more questions, which I can definitely send over to you, Louis, afterwards, and hopefully we can address them. And for those of you who have been asking, we will be sending out a recording of the webinar to all registered participants. So if you missed anything, feel free to re-watch at your leisure. And if you'd like to learn more about topics such as due diligence affecting investors in addition to accelerators, please make sure to register for our boot camp for accelerator managers from October 21st to the 25th. Again, applications are currently open, so please get that in as quickly as the class is filling up. And you can reach out to me at patrick.driscoll@500startups.com if you have any questions. And with that, I'll ask if Louis has any final words or comments, and then we'll close it for the day.
Hey, Patrick, thanks so much. And thanks, everybody, for listening. In closing, I just wanted to invite you to look at the end of the slides when they come to you by email or however Patrick distributes them. There's information about our website designed to help startups and investors go to market. It's called DLA Piper Accelerate. It's got market data. It's got free documents. It has our venture pipeline, which can connect you to deal flow by geography, by stage of growth, by industry vertical. And there's also some information about our guides to going global, which we make freely available. And this is really useful information on how to do business in countries around the world, whether it's setting up a subsidiary, paying taxes, registering intellectual property, paying equity, or hiring or firing employees. The guides to going global are really great resources. Patrick, thanks again for the opportunity to address your community, and we're just very honored to be a part of it and looking forward to the boot camp for accelerator managers later this fall.
Great. Thanks again, Louis, and goodbye to everyone. Have a good rest of your day, afternoon, or evening. Bye.